write a note on constitutionalism. Okay, so we will discuss this. Write a note on constitutionalism. Now, again, you can start with an intro that constitutionalism. What is constitutionalism? It is a philosophy which is essential for a democratic setup. Constitutionalism is very much important for people to live peacefully in a democratic setup, people to be able to express their opinion, their viewpoint and all that. It should not happen that government is becoming like supreme, ultimate power. Government is restricting people. That should not happen, but people should also be able to enjoy some rights in this. Okay, so this is very much important for a democratic setup. The term constitutionalism refers to a specific way of thinking or theorizing about the constitution. So when you hear this word constitutionalism, right, it is nothing but a philosophy that is applicable. It ensures that freedoms of individual are given primacy and state does not encroach upon liberty of citizens. If you look at the Constitution of India also, individuals are given some fundamental rights. Individuals are given so many freedoms. Freedom of thought and expression, right? Freedom to form assemblies, associations, freedom to practice, profess, propagate any religion they want. All these are given to us, right? So constitutionalism ensures that freedoms of individuals are given more importance. In India, whatever fundamental rights are guaranteed to us under Part 3, we are able to enjoy those rights. These are guaranteed rights. If it is violated, you can directly go to Supreme Court. You need not go to like the lower courts, then High Court, then Supreme Court. No, straight away you can go to Supreme Court to enforce your rights. These are so important, right? That is what constitutionalism is all about, that freedom of individuals should be given more importance. It should be given primacy. And the state should not encroach upon liberty of citizens. It should not happen that state or the government is doing whatever they feel like, and in that way they are encroaching, they are taking away the rights and freedoms which are given to us. That should not happen. It ensures that the government is limited. Government's power should not be like absolute. It has to be limited. Some limitations must be there, and prevents it from turning the democratic setup into a dictatorial or authoritative. It should not happen that it becomes a dictatorship where one person is like becoming absolutely powerful. Whatever he wants to do, he can do it. It should not happen that way, but Constitution should control the government as well. That is very much important for constitutionalism to prevail in a country. Okay, then you can move on to meaning. Constitutionalism is a philosophy which is evolutionary in nature. With time, it develops. With time, maybe some new concepts, new points may be added over here. But the central point of constitutionalism is limited government. It is fine. Even if you want, you can include some additional things in it. That constitutionalism also includes this, it also includes that. But the main point is limited government. Government's power should not be like unlimited or absolute. There has to be limitations in powers that government exercises. Constitutionalism recognizes the need for a government, but at the same time also insists upon restraining government's power. When we talk about constitutionalism, it is not that we should not have a government altogether. No, we need a government for all the things to function properly, right? For our needs, for our things to be taken care of, we do need a government. But at the same time, restraining government's power. We should not give absolute authority to government. Government is needed, but their powers must be limited. That is this whole concept of constitutionalism. Okay, is this part clear?
Yes, ma'am.
Okay, a constitution, if you have any doubts in between, you can stop me and ask, okay?
Okay.
A constitution is no guarantee for constitutionalism. Just because you have a constitution, that in itself does not guarantee that constitutionalism also would prevail. Just because you have a constitution, that does not guarantee that government's power is limited, people are able to enjoy their rights and all that. Even after having a constitution, it might happen that constitutionalism does not exist. You just simply have the constitution. Okay, so a constitution is no guarantee for constitutionalism. Just because you have a constitution, that in itself does not guarantee constitutionalism. A written constitution, to be more specific, like we have in case of India, is no guarantee for constitutionalism. Even Nazi Germany had a constitution, but it does not mean it adhered to the philosophy of constitutionalism. Just because you have a constitution, that in itself would not put limitations on the government. Government can still become like a dictatorship. It can still take away rights that people are enjoying. As the Supreme Court said in S.R. Chaudhary versus State of Punjab 2001 case, the mere existence of a constitution by itself does not ensure constitutionalism. Supreme Court also has made it clear. Just the existence of a constitution will not ensure constitutionalism. If primacy to democratic policies and individual rights is not given, constitutionalism cannot survive. If you are not giving importance to the rights that people are enjoying, like fundamental rights we have in India, if you are not giving importance to that, if you are not giving importance to democratic policies, constitutionalism will not survive in such a situation. Subtle assaults to individuals' rights, especially freedom of speech and expression and privacy, such as sedition laws, surveillance laws, undermine constitutionalism. Small steps might be the government is taking, that they are in an unjustified way punishing people for under sedition laws, right? Under surveillance laws, they are simply making the excuse and punishing people because they were enjoying or they were making use of their freedom of speech and expression. In such a case, what happens is those small steps taken all together, it would undermine constitutionalism. One point would come where constitutionalism itself would stop to exist. Right? In India also, we see there are so many cases filed under sedition laws. People are sent to jail for using, right, or for making use of their freedom of speech and expression. Last year, during this farmers' protest, there was this toolkit case, right? So many situations we see where just because someone was using freedom of speech and expression, case may be filed, FIR may be lodged against them. Those situations happen. And if those small situations keep on happening, at one point in time, it would undermine constitutionalism. Okay, again in RC Pudayal versus Union of India, the court said that mere existence of a constitution by itself does not ensure constitutionalism or a constitutional culture. It is the political maturity and traditions of people that give meaning to a constitution, which otherwise would merely embody the political hopes and ideals. For constitutionalism, a constitution needs to have some qualities which would either restrain the government from acting against its citizens or compel it to act, securing dignified life to each one of them. So in the constitution, it should be drafted in such a way that government is restricted, that you cannot take away rights that are given to people. Like if you take the example of Indian Constitution, yes, under Indian Constitution also, government is restricted from acting against citizens. It cannot It cannot violate the rights which are given to citizens, right? If fundamental rights are taken away, we can file a case against the state under Article 32 writ jurisdiction and compel it to act securing a dignified life. Under Constitution Part 4, we have something called as directive principles of state policy. Constitution itself is giving some directions to the government that you should function in this certain way. You need to keep these things in mind. You should try to achieve these things so that people are able to live a dignified life in the society. This is very much important. Okay, now this was like in general about constitutionalism. Now moving to constitutionalism in India. Does constitutionalism exist or not? If we take into consideration the Constitution of India, that we will discuss. Various constitutional provisions contain in itself, inter alia, the philosophy of constitutionalism, like a state by the Constitution. Constitution of India not just provides for rights and immunities to citizens, but it also delineates the character and structure of Indian state. The Indian state cannot function beyond what Constitution provides. Constitution is talking about every single aspect of the country. It talks about our rights, our obligations, directions to government, what would be different organs of the government, what will be their powers, functions, how they will work. Everything is specified in the Constitution. Right? Constitution clearly mentions rights and liabilities of different government officers. That means the Indian state, Indian government cannot function beyond what Constitution provides. Everything is clearly mentioned. What powers central government would have, what powers state government would have, what powers municipalities would have, how they will be elected, for how long they will serve. Every single thing is mentioned. What oath and affirmation they will take, right? Everything is mentioned. So beyond Constitution, they need, every single thing is mentioned there and they need to abide by it. They cannot go beyond the Constitution, right? They cannot ignore what is written in the constitutional provisions. Okay, then Article 21 and due process of law. What is Article 21? Have you come across this? Article 21 of Constitution? Fundamental rights. Have you come across this maybe in your college class?
Yes, ma'am, that's it.
Yes. So what is Article 21? Do you remember?
It is about life and liberty.
Yes, life and personal liberty. So Article 21 and due process of law. Article 21 of Constitution provides for life and liberty, that our life and our personal liberty cannot be taken away just like that. But yes, it can be taken away by following a procedure established by law. Take for example, under Indian Penal Code, it provides for punishment of death penalty. A person may be killed, he may be given death penalty for committing some of the rarest of rare crimes. This means that there has to be a legal justification. You cannot simply kill a person, but yes, if a judge gives death penalty, he can provide justification. He can say that this was a rarest of rare crime, and that is why deprivation of life and liberty is justified in this case. In this particular case, death penalty is the only punishment which should provide justice to the victim. The requirement of law for deprivation acts as a limitation on arbitrary exercise. Judge cannot use his arbitrary power. Judge cannot say that, okay, I feel like giving death penalty, so I'm giving. No, even that judgment has to be justified. When judge provides death penalty, judge would also provide justification why death penalty was given, why not some other punishment, right? Like that judge would try to justify. This is nothing but Article 21 and due process of law. You can take away life, but then proper procedure has to be followed. You need to provide justification for your act as well. Okay, there was this case Swaran Singh versus State of UP, 1998 case, wherein court observed that public power, including constitutional power, must never be exercised arbitrarily or malefied, and ordinarily guidelines for fair and equal examination are guarantees of valid use of power. Whatever powers are given, it should not be exercised in an arbitrary way, that okay, I have the power, I can use it the way I like. It should not happen that way. The power being of the greatest moment cannot be a law unto itself, but it must be informed by finer canons of constitutionalism. Whatever powers are given, you should not make arbitrary use of that. You should not say that, okay, fine, I have these powers, I would use it the way I like. No, it should have a proper justification. You should follow whatever guidelines are applicable, and in the best possible way, you can use your powers. Okay, so this is nothing but Article 21 and due process of law, that also in a way ensures constitutionalism, that even though death penalty provision is there, you cannot simply give this punishment. You need to justify your reasonings as well. Okay, then we have provisions relating to fundamental rights under Part 3 of the Constitution. Part 3 of the Constitution. So fundamental rights, especially right to constitutional remedy, which is given in Article 32. You can directly go to Supreme Court, file a writ petition. It acts against the arbitrary exercise of power of the state. Different departments of the government, they cannot simply violate your right like that. It is your fundamental right. If it is violated, you can make use of Article 32. You can go to the Supreme Court as well. Fundamental rights act as negative guidelines directing state what they should not do. If you look at Part 3 of Constitution, right, let me open the Constitution direct. When you look at the Constitution of India, Part 3, that provides for fundamental rights, most of the fundamental rights would start with like a negative obligation on the state. Okay, it would say that the state shall not do this certain thing, that certain thing for people to enjoy their rights. See, the state shall not deny, the state shall not discriminate, as in the state or various departments of the government should not do certain things so that we are able to enjoy our rights, so that we are able to enjoy equality before law, prohibition of discrimination and all that stuff. So when we talk about fundamental rights, Part 3, we clearly see that it provides for negative guidelines directing the state. It is directing the state that you should not do this, you should not do that, so that people are able to enjoy their rights in a proper way. Okay, I.R. Kohilo versus State of Tamil Nadu, a 2007 case, wherein court observed that the principles of constitutionalism is now a legal principle, which requires control over the exercise of governmental power to ensure that it does not destroy democratic principles. It's not just a philosophy anymore. It has become like a legal principle. Okay, so governmental power should not be enjoyed in such a way that it destroys democratic principles. And these democratic principles include protection of fundamental rights, right? People should be given some rights, some freedoms, so that they are able to deal with the situation, so that they are having enough freedoms to live their life in a better way. The principle of constitutionalism is based on principle of legality, which requires court to interpret the legislations on the presumption that Parliament would not intend to legislate contrary to fundamental rights. Part 3 of Constitution provides for 6 broad classification of fundamental rights. And then legislature is given an obligation that whatever laws you want to frame, you can frame it. But one thing you should keep in mind is that you should not be going against the fundamental rights. If Constitution of India is providing for equality, you should not frame a law that goes against this principle. If Constitution of India talks about maybe abolition of untouchability, you should not frame a law that allows untouchability. Okay, that should not happen. Otherwise, this law itself would be considered as void. That law itself will not be binding. Okay, for example, freedom of speech and expression given under Article 19(1)(a) can be restricted only on the ground which is mentioned in Constitution. Whatever fundamental rights we enjoy given under Part 3, these are not absolute rights. Okay, there are some restrictions. As in, yes, we have these rights, but under some situations, these rights may be taken away from us. And those restrictions are also mentioned in Constitution itself, like sovereignty and integrity of India, security of the state, friendly relation with foreign states, public order, decency, morality, etc. Okay, and on these grounds only you can take away this particular right. You cannot impose your own grounds. Whatever is mentioned in Constitution, those grounds would be applicable. Based on those grounds, you may take away fundamental rights, not something which has been created just for the sake of creation. That would not happen. Okay, is this part clear?
Yes, ma'am.
Any point you want to be repeated?
No, ma'am, I understood.
Okay.
Ma'am, yeah, for every case, for everything, we have to write case laws, ma'am.
Sorry?
For everything, we have to write a case laws, ma'am.
Not like everything. See, there might be some situations like feature of Constitution or types of Constitution. Their case law is not as such relevant, right? But there would be some topics wherein case law is very much relevant. So you need to consider, like this one here also case laws are somewhat relevant. So I have added it. There might be some questions where it is not relevant. Like yesterday we discussed, right? Define Constitution. What are the kinds of Constitution? Their case law is as such not relevant. Okay, so depending on the question, you can decide whether to write case laws or you can skip that as well.
Okay.
All right, so written Constitution. Indian Constitution being written, codified and regarded as supreme law of land, the Indian state is thus controlled and restricted. Whatever is written in Constitution, that we need to abide by. In fact, when you look at the oath and affirmation that is taken by President, Vice President and all, right, they make a promise that we would respect the Constitution. Whatever is written in Constitution, we would follow that. Okay, that means they are, all these government departments, officials, they are controlled by the Constitution. They are not above the Constitution. Okay, so Indian state is controlled and restricted by provisions of Constitution. We need to follow it. The mandate of the state cannot go beyond the directive principles of state policy enshrined under Part 4 of Constitution. Part 4 of Constitution provides for some directives to the government, and government should try to follow or abide by those principles. Whenever possible, wherever possible, they should keep these principles in mind and try to fulfill them as well. Further, a written constitution provides for fundamental law of the land, and thus legislature is bound by the constitutional principles. Whatever is written in constitution, legislature, the lawmakers, the parliament also need to abide by it. Parliament cannot frame whatever laws they want. It has to be in accordance with provisions given in constitution. They cannot violate constitution basically. Okay, so this is nothing but written constitution. Then we have separation of power. So when we talk about separation of powers, there are mainly three different organs of the government. Okay, different powers and functions are divided amongst three organs: executive, legislature, and judiciary, and they perform their own powers and functions. But when we say they perform their own powers and functions, sometimes these powers may be overlapping, as in executive may have some say in legislature, legislature may have some say in executive, like that. And this is in order to ensure check on the power of the other. It should not happen that one organ is becoming like arbitrary, whatever they feel like they are just doing it. That should not happen. Okay, there are three different organs, they are given specific functions so that things happen very quickly. They just focus on their own area. But it's not like all these three organs are like completely not related to each other. They are somewhat, sometimes powers and functions are overlapping, so that they do not misuse their powers, they don't become arbitrary, or they don't become like unreasonably, they don't use their powers. That is also taken into consideration by way of separation of power. State entity versus entity of Delhi versus Union of India. Here Chief Justice Mishra observed that the essence of constitutionalism is the control of power by its distribution among several state organs or offices in such a way that each of these are subjected to reciprocal controls and forced to cooperate in formulating the will of the state. It should not happen that they are becoming absolute, but they should function in a very well organized way. They should, cooperate in formulating will of the state. Ultimate purpose of all of them should be welfare of the state or will of the state, right? They should work for the good and not for making use of their own powers. Then you can put a conclusion that the design and character of Indian Constitution ensures that powers of the executive and legislature is limited, so that the discretion given to these organs does not turn into arbitrariness and arbitrary exercise. It should not happen that they become like arbitrarily whatever they feel like they are doing it. That should not happen. That is taken care of while framing the Constitution. The fundamental rights, basic structure, federal setup of the administration, amendment process, all limit the state in a particular way. All these different provisions that we see in the Constitution, somewhat or the other, right? To some extent or the other, all of these are contributing in ensuring constitutionalism. And constitutionalism is nothing but limited power of government, so that people are able to enjoy their rights, people are able to enjoy their freedoms, and democratic setup can be maintained in the state. Okay, that is the ultimate purpose of this theory called constitutionalism. Okay, is this answer clear?
Yes, ma'am.